Friends, very warm welcome to my business laws channel. In my last two videos, friends, I had covered contract of indemnity and guarantee. So this is the third video to the special contracts. In this video, I will be covering contract of bailment. So first of all, friends, I'll cover meaning of contract of bailment, then essential features of contract of bailment. Now you see my video, watch my video, where all frequently asked questions in Delhi University. I have covered in that video. Special contracts, three contracts in that I have given all possible questions. Contract of indemnity and guarantee, contract of bailment and pledge, and then contract of agency. So all possible questions I have given in that. You can watch that video also. And all those headings I will cover in this video. So let us start now. The meaning of bailment. What is bailment, friends? As per section 148 of ICA, Indian Contract Act, bailment is the delivery of goods by one person to another for some purpose upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering them. So friends, now I will take up all the essentials of contract of bailment, in which the entire definition will be very, very clear. Okay, so what is bailment? Bailment is a delivery of goods by one person to another. The goods are delivered for some purpose. There are multiple purposes. So they are always delivered for some purpose. Or they are to be disposed of as per the directions of the person delivering them. So let me analyze this definition now. Friends, there are three parties involved. There are two parties involved in the contract of bailment. The person who delivers the goods is known as bailor. The person to whom the goods are delivered is known as bailee. And this transaction is known as bailment. So we can take number of examples. A lends his book to B to take examination. So A is the bailor and B is the bailee. Here, friends, the contract of bailment is without consideration, because A is not going to charge anything from his friend B. So A lends his book to B, B is the bailee, A is the bailor. A gives his car to B for his personal trip. A and B are good friends. Now B has to enjoy a certain trip, and A is such a person that he wants to help his friend. So he gives him his car and he says, okay, you plan your personal trip and enjoy. Here also, friends, A is not going to charge anything from B. So this is the bailment which is without consideration. He gives his watch to B as a security of loan. So here, A needs money and he has given his watch to B, where watch will be kept as a security of loan. When A will repay the debt to B, then B will return his watch to A. So this contract of bailment is non-gratuitous, or we can say in other words, it is with consideration or reward. So friends, I have explained all these terms, and now I will take up the contract essentials of contract of bailment. So when I explain all the essentials of contract of bailment, the definition which is given under section 148 will be very, very clear to all of you. So let us begin now, friends. The very first point is contract between the parties. The contract of bailment arises, it always arises from an agreement between bailor and bailee. So it may be this contract may be express or implied. For example, friends, when we talk about finder of goods, finder of goods is the person who finds goods lying on the road or in the street. He takes the goods into his own custody and then he tries to find out the real owner. Till the real owner is found out, he acts as a bailee. So here is the contract between the true owner and the finder, which is implied. So moving ahead, friends, the second is delivery of goods. Now, when the delivery of goods may be of two types. One is actual and second is constructive. Actual delivery of goods. Actual delivery of goods may be made by physically handing over of goods by the bailor to the bailee. So here, friends, when goods are physically handed over, any example you take, a delivery of computer to the mechanic for repairing purposes. Any movable item, when it is delivered by one to another or for some purpose, then this is the example of actual delivery of goods. Now, on the other hand, the meaning of constructive delivery of goods, where goods are not actually delivered, but means of obtaining the goods are delivered. Say the railway receipt may be given. So this is the example of constructive delivery of goods. Now, delivery of goods for some purpose. Goods are always delivered for some purpose. Now, before this, the third point is no change in the ownership. Ownership lies with the bailor. Only, friends, the goods are delivered, but it doesn't mean the ownership passes from the bailor to the bailee. So it is just the possession which passes, but ownership is always retained by the bailor. Now, moving ahead, the fourth point is delivery of goods for some purpose. Section 148 provides that under the contract of bailment, goods must be delivered for some purpose. Purpose could be, friends, lending of goods, dry cleaning, repairing, change of form, carriage, etc. Or it may be safe custody also. So, friends, all these are the various purposes of delivery of goods under the contract of bailment. Then, contract of bailment is concerned with the movable property. Movable property is the next point. Movable goods. So, movable goods, because it is a delivery of goods by one person to another. So, money is excluded from the category of movable property. Land, building, they are not movable. That is an example of immovable property. So, friends, movable property, because contract of bailment is always concerned with the delivery of goods by one person to another. And now, friends, the same goods are to be returned. Return of specific goods is another point, because same goods are to be returned when the purpose is over. The same goods are to be returned by the bailee to the bailor. Say, for example, friends, A has given his Acer computer to B for repairing purposes. Then it is the same Acer computer which has to be returned after the computer has been repaired by the bailee to the bailor. So, return of specific goods after purpose is over is another example of this, that specific goods are to be returned by the bailee to the bailor after the purpose has been accomplished. Now, friends, I'll take up the heading benefits derived by the parties. That is, I'll be talking about kinds of bailment. Now, there are two bases of classification of bailment. First one is benefits derived by the parties, and second is reward or consideration. Now, on the basis of benefits derived by the parties, we can classify the contract of bailment into three categories. The categories are before you, friends. First one is bailment for the exclusive benefit of the bailor. Second is bailment for exclusive benefit of bailee. Third is bailment for the mutual benefit of both the parties, bailor and the bailee. So, bailment for the exclusive benefit of the bailor. For example, A, while leaving for Mumbai, hands over his car to B for safe custody. Now, this is only for the benefit of bailor. Bailor maybe doesn't have the parking space, so he leaves his car in the safe custody of his friend. So, when he comes back, then he takes a possession of his own car from the person. So, here the bailment is for the exclusive benefit of the bailor. Now, bailment for the exclusive benefit of the bailee. Now, A lending is booked to B. Here the B is going to get the benefit because it is for his exclusive benefit only. And where both the parties are going to get the benefit, friends, delivery of watch, delivery of computer for repairing purposes, or where A has delivered goods, A has delivered goods to railway for its transmission to the buyer at some other place. Now here also both the parties are going to get the benefit. Seller is delivering the goods to the buyer through the delivery company. So A will also get the benefit and B will also get the benefit. But here the bailment is for the benefits of both the parties. Now consideration. On the basis of consideration or reward, we can classify the conduct of bailment into two categories. First one is bailment without reward or gratuitous bailment. And second one is, friends, bailment with reward or non-gratuitous bailment. So bailment without reward or gratuitous bailment. The example two examples have taken, keeping his car in the safe custody of another, and A lending his book to B to take the examination. Here there is no reward or consideration. So the bailment is gratuitous. Another example, friends, where the computer or watch, motorbike, it is given for repairing purposes. Here, these are the examples of non-gratuitous bailment, because both the parties are going to get the benefit, bailor as well as the bailee. And now, friends, hurriedly, I will take up the distinction between gratuitous and non-gratuitous bailment. So let us start now. The first one is, friends, consideration, gratuitous bailment. No consideration. There is no consideration between the bailor and the bailee, but there is consideration between the bailor and the bailee. Bailment, gratuitous bailment may be for the benefit of one of the parties, bailor or bailee. But when we talk about non-gratuitous bailment, it is for the benefit of both the parties, bailor and bailee. Now, bailor is responsible, for the known defects only in case of gratuitous bailment. The defects with which he is aware of. If he knows that, his carriage is unsafe, okay, and by using that unsafe carriage, the bailee suffers a certain amount of loss, then in that case, he has to compensate the bailee for the loss. But he himself doesn't know whether the carriage is safe or not. Then in that case, whatever loss is suffered by the bailee, he will not be under obligation to compensate the bailee for the loss. So friends, we can say bailor is liable for known defects only. But in case of non-gratuitous bailment, bailor is liable for both the defects, whether he knows about them or he doesn't know about them. If bailee suffers any amount of loss, it is a bailor's responsibility to compensate the bailee for the loss. And then, friends, bailor is entitled to terminate bailment before the expiry of specified period. Here in case of gratuitous bailment, but in case of non-gratuitous bailment, he is not entitled to terminate bailment before the expiry of specified period. So gratuitous bailment is terminated by death of the either bailor or bailee. Bailee dies or bailor dies, the conduct of gratuitous bailment will come to an end. But it is not terminated, by the death of the bailor or the bailee. So friends, this is all about the various points of distinction between the bailor and the bailee. Now moving ahead, friends, I will take up duties of bailor. The first duty of gratuitous bailor, to disclose the faults in the goods bailed. Whether he has to disclose the faults in the goods bailed or not, whether known defects or unknown defects, we have to make the distinction between gratuitous bailor and non-gratuitous bailor. Just now, friends, I have explained the duties of gratuitous bailor are different from duties of non-gratuitous bailor in this regard. Gratuitous bailor is liable for known defects only, but non-gratuitous bailor is liable for known defects as well as unknown defects. So I have taken the example and I have explained, and if you still have any doubt, you can always write in the comment section. Moving ahead, friends, if bailee suffers certain amount of loss due to the defective title of the bailor, then bailor is responsible to the bailee for any loss which he may sustain due to the reason that bailor was not entitled to make payment. What bailor has done, friends, bailor has stolen the goods, and then he has bailed those goods with the bailee. And then the real owner comes to the bailee, he says, these are my goods. Then, in that case, whatever loss is suffered by the bailee, he has the right to be compensated by the bailor, because he was not the true owner. And we always presume the person who is bailing the goods has the true title to the goods. It is the duty of the bailor to receive back the goods from the bailee after the purpose is over or after the period is over. So if A has left his car in the safe custody of his friend to B for a week period, then friends, it becomes his duty. He must take his car after 2 days. So it is a duty of the bailor. He must receive back the goods from the bailee after the purpose is over. Now, duties of bailee, I would like to discuss. Now, in all the cases of bailment, the bailee is bound to take as much as care of the goods bailed to him as a man of ordinary prudence. So this point is, friends, duty to take reasonable care of the goods bailed. It is a duty of the bailee that he must take the reasonable care of the goods bailed as if he takes the goods reasonable care of his own goods. He should not make distinction that no, these goods do not belong to him, so he should be negligent regarding that. If due to his negligence certain loss is suffered by the bailor, then bailee has to compensate the bailor for the loss. If the bailee makes bailee is not entitled to make unauthorized use of the goods bailed. If he has taken certain horse for his own riding purposes, then he should not lend it to his another friend. It means he is making unauthorized use of that horse. If he does so and the bailor comes to know, bailor has the right to put an end to the contract. So unauthorized use of the goods will entitle the bailor to terminate the contract. Now, bailee is not allowed to mix up the goods. If bailee has mixed up the goods with his own goods with the consent of bailor, then there is no problem because bailor has given his consent. And where the bailee mixes up the goods with his own goods without bailor's consent, and the goods are separated, because those goods can be separated from the bailee has his own goods. Bailee has taken the goods from bailor also, and he has mixed up these goods, and he has not sought the consent of bailor. And goods are separable. We can separate, which goods belong to the bailor and which goods belong to the bailee. Then in that case, the expenses of separation will have to be borne by the bailee. And where the mixture is not separable, that is, we cannot separate which goods belong to the bailor and which goods belong to the bailee, then the bailee has to suffer the loss. He will have to compensate the bailor for the loss. The bailee should return the goods to the bailor without demand or on expiry of the specified period or accomplishment of purpose. So friends, this is again the duty of the bailee. He must return the goods to the bailor after the purpose is over, or after that specified period is over. And if there are joint owners, then bailee has a right. He can return that item to any one of the joint owners. If there are 4 persons who are the owner of the item which has been delivered by the joint bailors or one of the bailors to the bailee, then bailee has a right. He may deliver the goods to any one of those joint bailors. In the absence of contract to the contrary, bailee is bound to deliver to bailor any increase or profit accruing from the goods bailed. Say, bailor has left cow with the bailee, because he has planned certain trip. Now, in the absence of bailor, cow is blessed with the cow. Then in that case, bailee must return cow along with the cow. Now I'll take up friends' rights of bailor. Friends, duties of bailee are the rights of bailor, and vice versa. And duties of bailor are the rights of bailee. So I have considered, I have discussed in the earlier headings, duties of bailor and bailee. And so the rights of bailor, points are there. You can just go through the points, you'll be able to understand, because duties of bailor are the rights of bailee and duties of bailee are the rights of bailor. So all points I have covered earlier, only the difference will be in the presentation. And if I find any new point is there, that I will explain. So rights of bailor. Right to enforce bailee's duty. He has a right that he can enforce all the duties of bailee. Right to terminate the contract of bailment. He has a right to terminate the contract of bailment if he comes to know that period is over, purpose is over, or unauthorized use of the goods that is being made by the bailor. Right to demand the goods back. He has the right to demand the goods back. Okay, take back the goods, because after all the ownership lies with the bailor. Right to demand the return of the goods on the completion of bailment. So period is over or the purpose is over, then the bailor has the right to demand his goods back. Right to claim any increase or profit. Any accretion to the goods belong to the owner. I have given you example of cow and calf. So it is a duty of the bailee, he must return, which is the right of the bailor. He has the right to claim any increase or profit. Right to claim damages caused in the case bailor provides faulty goods. So friends, even bailor has provided defective goods to the bailee, and due to the defective goods the bailee has suffered an amount of loss. Then it is the right of the bailee that he has a right, he must be indemnified by the bailor. Right to claim reimbursement of necessary expenses. So these are the rights of bailee, friends. Right to claim damages caused in the case bailor provided faulty goods. Right to claim reimbursement of necessary expenses. Necessary expenses, if cow is left, then feeding expenses to the cow are the necessary expenses. Now these will be borne by the bailor. The right of indemnification in case of gratuitous bailment. So gratuitous bailment is without consideration, without reward. And in this case, if bailee suffers any amount of loss, bailee has a right to be indemnified by the bailor. Right to interplead. Bailee also has a right to interplead, to argue if he finds the bailor was not the true owner of goods, but somebody else, a third party, was the owner of goods. Right to claim damages in case of bailor refuses to receive back the goods. So it is a duty of the bailor, friends, he must get back his goods after purpose is over. But if he has refused to take back the goods and safe custody charges are incurred by the bailee, then it becomes the right of the bailee. He must be indemnified for that. Right of the lien. Lien is right to retain the goods. If bailee has to take certain charges from the bailor, and bailor has not paid, say bailor has given a piece of cloth to the bailee tailor for stitching purposes, but stitching charges have not been paid by the bailor to the bailee, then bailee has a right of lien over the stitched cloths, because still his charges are unpaid. He has the right to retain them. Okay, so right to retain the goods is known as the right of lien. Right to sue a wrongdoer. If the goods are in the possession of bailee, somebody comes and causes loss to the goods, then in that case, the bailee has the right to take action against the wrongdoer. So friends, I have explained all the the rights and duties of bailor and the bail. Now I'll take up lien. Lien means the right of a person to retain the property or goods belonging to another until the debt is paid. Okay, lien, L-I-E-N. Lien can be of two types. One is the particular lien and second is general lien. Now, this lien it is exercisable by the bailee against those goods on which some labor or skill has been exercised or expended. So we are talking about particular lien. When we talk about dry clean cloths, when we talk about stitched cloths, okay, and he can retain such goods until he receives the due remuneration for the services he has rendered. So I've given you the example of stitching of cloths. The tailor is not going to return the stitched cloths to the bailor owner till his stitching charges are paid by the bailor to the bailor. Because in respect of those stitched cloths, certain labor or skill has been exercised or it has been expended. The bailee must have rendered some services on the goods. So friends, bailee is entitled to the right of lien provided some conditions are satisfied. Okay, so bailee must have rendered some service on the goods. Performance of the service in full. Services must have been performed in full. It is not there the cloth has not been fully stitched. Payment must be done. Bailee cannot exercise right of lien if he performs the services on credit. If he has allowed credit to the bailee, he says, okay, I will make you the payment after, bailor said to bailee, I'll make you the payment after 1 month. And bailee has given his consent. Then in that case, bailee will not have the right to exercise his right of lien. Bailee must be in possession of goods. Friends, remember, right of lien is always possessory in nature. So far as the goods are in the possession of bailee, he can exercise this right. Once the possession is lost and the right of lien is also lost, he will be paid for services rendered. In case he will be paid for the services which he has rendered in case of those goods which are in his possession. Now, he has given rough diamond to be a jeweler to be cut and polished as per bailment. Now, he is entitled to retain this item till he is paid. So, this is an example of particular lien. I have told you he has rendered his services, cutting, polishing. Okay, he has rendered his services. Till he is paid his charges, he is not going to return this diamond to the owner. Okay. Now I will talk about general lien, a right which entitles bailee to retain all the goods or property of another until all his claims are satisfied. This right is available to all bankers, factors, wharfingers, attorneys of high court and police brokers. And this is the policy brokers. In absence of any contract, the bailee can retain the goods as a security. Now, hurriedly, friends, I'll take up these 3 points of distinction between particular lien and general. The particular lien can be exercised against particular property only, on which the bailee has expended some skill or labor. But when we talk about general lien, it can be exercised against any property or goods. Say, for example, friends, a person has got FDRs, in the bank, and he has taken overdraft from the bank and he has not paid. And now he wants to go to the bank and to get his FDR and cash. The banker may say, no, I will not allow you to encash your FDR unless and until you pay me that amount of loan which you owe to me. Okay, so this is the general lien. Here we are talking about. So general lien is always exercised for the general balance of account. And when we talk about particular lien can be exercised for the payment of remuneration for the performance of services. In the context of stitching example, stitching charges. So far as the stitching charges are unpaid, he can exercise this right of particular lien. Who? The tailor. Okay, once they have been paid, then tailor has no right to exercise particular lien. And entitlement, entitlement is different. Now, both the particular lien can be exercised by all bailees. But general lien, just now I've told that can be exercised by ward fingers, policy brokers, etc. etc. And now, how the conduct of bailment comes to an end? It comes to an end in various ways. How the bailment terminates on expiry of specific period, when the period is over. Say Baylor has left his car with bailee for 15 days, and 15 days are over, and he comes back and he must take his car from weepers. Baylor dies or bailee dies, and the conduct of bailment comes to an end. Purpose has been accomplished. So bailment also comes to an end when the purpose is over. Okay, or in case of premature termination of bailment, it can also be terminated before the expiry of the period, because bailee is not allowed to make the unauthorized use of goods. And if he makes, then bailor has the right to put an end to the contract of bailment. Okay, so friends, there are various purposes. There are various cases in which the contract of bailment will come to an end. So friends, it is all about this contract of bailment. I hope you will like the content, and if you have any doubt, you can always write in the comment section. Friends, do subscribe to my channel if you are not subscribed yet. Keep smiling and stay blessed always. Okay, friends, we'll meet soon. Goodbye.